Hey, what's going on? This is Instructor Mike. Let's go on ahead and dive into this sad story out of a Chicago suburb where a woman who filed an order of protection received a terrible result. I don't necessarily like reporting on these type of stories, but it is a story all too familiar. So without further delay, let's dive into it. All right, so this is protected under Title 17 United States Code Section 107 U.S. copyright law. This video is being used for fair use, criticism, teaching, things like that. I am not a lawyer. This is not legal advice, but as a criminal justice lecturer and instructor, a trauma-informed coach, and a person who's specializing in traumatology and things of that nature, we bring a unique perspective, not so unique, but you get what I'm saying. We bring a perspective to this channel that encourages people to do what they have to do to protect themselves. And as many times as you've heard me say things relative to the order of protection not being able to protect you, this is a sad story out of the city of Joliet. So let's go on ahead and dive right into it. Here we go.
In with the CBS 2 investigation, the family of a Joliet mother stabbed to death by her estranged husband in a horrific murder-suicide is speaking out only on 2.
CBS 2 investigator Megan Hickey looked into her legal fight against her abuser and the last efforts she took to protect her little boy.
Melissa Odd-Headley had taken out 2 orders of protection against her then estranged husband before he took her life on Saturday. Her family says they want other survivors of domestic violence to hear her story so that they can get help. Melissa Odd-Headley's older brother, Daniel Ronkowski,
all the mulch, all the new flowers,
showed me the flower beds he was helping his little sister plant on Saturday. When they ran out of mulch, he said he offered to run to the store. He was only gone a few minutes when he got a call to come back.
It was a gift that God gave me that I got to spend the last hour with my sister doing something for her.
Odd-Headley's estranged husband, Michael Odd-Headley, had been watching them from a distance and confronted her inside the home once her brother was gone. Her dad tells me she put down their 3-year-old son.
He said, Mommy told me, run and hide, run and hide. So he ran in by one of the corner bushes.
After a struggle inside, she ran for a neighbor's house. The Joliet police say that's when Michael Odd-Headley caught up to her
in the middle of the street
and stabbed her multiple times in the chest with a kitchen knife before turning the knife on himself.
Now, I do have to sit here and talk about this because, you know, you often hear politicians, especially in Illinois, talking about, having anti-gun messages, and I definitely understand, wanting people to be free from violence because a gun is often the most popular tool that's used and actually the rather easiest to access and the easiest to use. But what do we say here in this given situation where she had not 1 but 2 orders of protection? By all accounts, we'll let the story finish, but she didn't have a firearm. She didn't have a concealed carry license. She didn't even use a tool that's in common usage. A knife. And here we go. Got a father. You saw him. Got a brother. You saw him as well. You saw those 2 people. Father, brother, and no concealed carry license in Illinois. The Illinois concealed carry law has been in place since 2013. Now, granted, you don't have to get concealed carry. You don't have to. But if domestic violence has always been a thing, and it always has been, this is not a new subject. Why do we wait until this happens to then say, well, one's voice should be raised, one's voice should be elevated, we should know this person's story and rest in peace and celebrating the life of this young woman, but she should still be alive today. Where's the father's plan for teaching the daughter how to protect herself? Where's the brother's plan for teaching your sister how to protect herself? Better yet, where's your plan, father, for protecting yourself? Where's your plan, brother for protecting yourself. Now, this may sound like blaming the victim. This may sound like that. But I really want you to understand that there is such a criminological theory of protecting yourself. There's victim precipitation, the things that we do to make it likely for us to become a victim of a crime. There's another theory called routine activities theory. Routine activities theory. And that is the theory that what makes a person a suitable victim, if you will, is two other things. Let me see if I can pull it up because I want you to see it. I don't want you to be like, well, this is a Instructor Mike exclusive. No. Routine activities theory. Matter of fact, I'm gonna let the rest of the story play out and then we'll pull it up. And then I want to educate you on this because you come to this channel and you want information, you get information, but I want to leave you with a tool.
She ran the opposite direction of her child, so that way he could be safe.
Odd Headley, who had just turned 35 the day before, had filed for divorce.
I knew it was, what's the word, tumultuous.
Court records show she had also filed for orders of protection in January 2022 and November of 2023. Her family says they were aware of a case of physical violence in the fall, but it was the husband who successfully filed for an order of protection against her.
Just mind-blowing the system works that way.
While not associated with this case, Benna Crawford with Legal Aid Chicago tells me it's not uncommon for abusers to weaponize the legal system in this way.
And the reason that this happens is that when an abuser obtains an order of protection against their victim, it becomes much harder for that victim to escape.
Daniel tells me he came back and finished planting.
Now, here's the problem that I hear with what she said is that when an abuser weaponizes the system, it's harder for the victim to escape. But here's a question that I ask. Is this something that is an anomaly, or is it usually the case that a woman, or even a man, but a woman will use the system against a man when there's no actual evidence of allegations? So that's a conversation that definitely need to be had. But here's one thing I want to go on ahead and focus on right here, and I'll blow it up so that you can see the theory of routine activities. Right here you have on the top a motivated offender, here you have a suitable target, and here you have the absence of a capable guardian. And that's the theory called routine activities theory. It's a theory that states the occurrence of a crime is likely if there is a motivated offender, a suitable target with the simultaneous absence of a capable guardian. A capable guardian. You can tell by the language over here, this is in German, in Deutsch, right? The main proponents of this theory is Lawrence E. Cohen, Marcus Felsen, and Ronald Clark. Crime rates depend on constantly changing lifestyles and behaviors of the population, depending upon the time and place. Three factors that are decisive for Cohen and Felsen are responsible for the occurrence or absence of criminal behavior. And of course, it may vary. But in predatory crime, a motivated offender, the husband was motivated to take the life of his wife. We're not talking about whether it was legal or not. We obviously know it's illegal, right? But then a suitable target. What more of a suitable target do you have than a person who doesn't want to defend themselves? And I'm not saying she doesn't want to defend herself. I think that's a stretch. But chooses. I think that's a better word. Chooses not to defend themselves. And then you got the absence of capable guardians. You look and see here that the Joliet police showed up when? After it was over. After it was over. The police always show up when it's over. Are they ever really there? Are they ever really there before it occurs? The town of Castle Rock versus Gonzalez. I'm going to try to pull that up real quick because I want you to hear out of Justice Scalia's own mouth. Antonin Scalia. Let's let the rest of this story play, and then we'll go on ahead and hear directly from him.
When Michael Odd Headley caught up to her
In the middle of the street.
and stabbed her multiple times in the chest with a kitchen knife, before turning the knife on himself.
She ran the opposite direction of her child, so that way he could be safe.
Odd Headley, who had just turned 35 the day before, had filed for divorce.
I knew it was tumultuous.
Court records show she had also filed for orders of protection in January 2022 and November of 2023. Her family says they were aware of a case of physical violence in the fall, but it was the husband who successfully filed for an order of protection against her.
Just mind-blowing the system works that way.
While not associated with this case.
Now, here's the question that I do have, and I'm curious. I'm really curious because of the jurisdiction that was the Circuit Court of Will County. I'm curious as to what allegations were made by him to where his order of protection was granted as well. I'm an independent person. Just because of the gender or race, I don't take sides. I look at the evidence. What was he able to say in this situation? What was he able to say? I'm curious about it. It's still a question for me. I'm going to end with this. We are on the website, oya.org. oya.org. Those of y'all who don't know what oya.org is, this is the United States Supreme Court's website. United States Supreme Court's website when it comes down to researching case law, things of that nature. And I want you to hear the words of Antonin Scalia when he talked about, in the case of Town of Castle Rock versus Gonzalez, this is an often cited case about the government not necessarily having a specific duty of protection toward you. I end with this.
The opinion of the court in Town of Castle Rock versus Gonzalez will be announced by Justice Scalia.
This is case number 04278, Town of Castle Rock versus Gonzalez. I thought Castle Rock was a 1920s dance, but it's also a town in Colorado. The case is here on writ of certiorari to the Court of Appeals for the 10th Circuit. The facts are truly horrible. Jessica Gonzalez, the respondent, sued the town of Castle Rock in federal district court, alleging that the town had violated her rights under the 14th Amendment's Due Process Clause when its police officers, acting pursuant to official policy and custom, she alleges, failed to respond to her repeated efforts over several hours that her estranged husband, her repeated reports over several hours that her estranged husband had taken their 3 children in violation of her restraining order against him. The restraining order had been entered as part of a divorce proceeding. It generally prevented the husband from coming within 100 yards of the family home, and it allowed him only limited contact with the children. The back of the restraining order included a notice for law enforcement personnel which tracked the statute and which said, quote, "You shall use every reasonable means to enforce this restraining order. You shall arrest, or if an arrest would be impractical under the circumstances, seek a warrant for the arrest of the restrained person when you have information amounting to probable cause that the restrained person has violated any provision of this order." Early one evening in 1999, the respondent's husband took their children without making the advance arrangements that the order required. Respondent first called the police at about 7:30 that evening. When officers came to her house, she showed them the restraining order and asked them to enforce it and return her children. They told her to call back if the children did not return by 10 p.m. She called again at 8:30 p.m., telling them that she had spoken to her husband, who had the children at an amusement park in Denver. Again, they told her to call if the children were not returned by 10 p.m. Shortly after 10, she called back, but was now told to wait until midnight. She called again at midnight and again at 12:10 a.m., and then went to the police station to file an incident report at 12:50 a.m. Finally, at 3:20 a.m., her husband showed up at the police station shooting a semi-automatic handgun. The police shot him dead and discovered in his pickup truck the bodies of all 3 children whom he had already murdered. Respondent's lawsuit alleged that she had a property interest protected by the Due Process Clause in the enforcement of the restraining order. The district court concluded otherwise and dismissed the suit. On appeal, however, a 6-5 majority of the in-bank 10th Circuit found that she did have a protected property interest in enforcement of the terms of the restraining order, and that by failing to give serious attention to her request to enforce the order, the police had violated her due process rights. We granted certiorari, and in an opinion filed with the clerk today, we reversed the 10th Circuit. The Due Process Clause says that no person shall be deprived of life, liberty, or property without due process of law. Property for this purpose does not include everything that might be described as a governmental benefit. Our previous cases have explained that an individual must have a, quote, legitimate claim of entitlement, close quote, to the benefit, and that such entitlements are created by some independent source, such as state law. Respondent asks us to defer to the 10th Circuit's conclusion that Colorado law created such an entitlement here. We think that such deference is inappropriate in this case because the 10th Circuit decision did not draw upon any deep well of state-specific expertise, and because if we were simply to accept its conclusion, we would necessarily have to decide conclusively a federal constitutional question. We conclude that Colorado law did not give respondent an entitlement to enforcement of the restraining order. The key question involves the statute that says police, quote, shall arrest, or if an arrest would be impractical under the circumstances, seek a warrant for the arrest, close quote, of somebody they have probable cause to believe has violated a restraining order. There is a well-established tradition of law enforcement discretion, even in the face of apparently mandatory arrest statutes. A Colorado officer would likely have some discretion to determine that the circumstances of a violation or competing duties counsel against enforcement in a particular instance. The practical necessity for discretion is even more apparent when, as in this case, the violator is not present at the scene and his whereabouts are unknown. In such circumstances, the statute does not appear to require officers to arrest, but only to seek a warrant. That, however, would be an entitlement to nothing but procedure, which cannot be the basis for a property interest. The judge would have some discretion in the issuance of the warrant, and the police would have some discretion in the enforcing of it. Even if the statute could be said to make enforcement mandatory for the police, that would not necessarily mean that respondent has an entitlement to enforcement.
Even if the statute could set to make enforcement mandatory for the police, that would not necessarily mean that the respondent has an entitlement to enforcement. So even when you get an order of protection and the statute set to make enforcement mandatory for the police, it wouldn't necessarily mean that you have an entitlement to the enforcement. So let that process.
The statute speaks of protected persons, but only in connection with other matters other than enforcement. In particular, it speaks directly to the protected person's power to, quote, initiate, close quote, civil contempt proceedings, and to, quote, request, close quote, that the prosecutor initiate criminal contempt proceedings. This contrasts tellingly with statutory silence about any power on the part of the protected person to request, much less demand, that an arrest be made. Finally, we note that even if we thought otherwise about Colorado's creation of entitlement, it is not clear that an individual entitlement to enforcement of a restraining order could constitute a property interest for purposes of the Due Process Clause. Such a right would have no ascertainable monetary value and would arise incidentally out of a function that government actors have always performed, namely the function of arresting people who they have probable cause to believe have committed a criminal offense. Accordingly, we reverse the judgment of the Court of Appeals. Justice Souter has filed a concurring opinion, joined by Justice Breyer. Justice Stevens has filed a dissenting opinion, joined by Justice Ginsburg.
And that was a 7-2 decision. So the majority of the Supreme Court of the United States rejected her claim of a property interest to protection under Title 42, United States Code, Section 1983. It's your job to protect you. It is your job to protect you. It's your job to protect you. You have to be the one who does that job of protecting you. I don't know any other way to stress it. And it's a shame that things like this happen. It's a shame that things like this happen. She should still be alive today. That man who tried to harm her should be switching places with her. That's what should be happening. Should be switching places with her. She should not be in this position. What are your thoughts? Sound off in the comments. Okay. This is Instructor Mike. And yes, again, you have been trained. I'll catch you on the next reaction video.